The U.S. Immigration Service continues to push back on efforts by local contractors to get H-2B visa petitions approved. In court papers, attorneys for the USCIS confirmed the denial of H-2B visas in recent months stems from abuse of the system.
Year in, year out, blanket approvals of H-2B workers became so standard that approvals were almost expected. But now it appears that the U.S. Citizenship and Immigration Service is cracking down on what they're now referring to as abuse. Attorney for USCIS Heather Sokolower filed a motion to dismiss the Guam Contractors Association's lawsuit once again on the basis that not only does the District Court of Guam lack jurisdiction, but on the very entitlement that local contractors seem to claim because of a historically high approval rating. GCA and several other local contractors are seeking a preliminary injunction against the USCIS and U.S. Attorney General Loretta Lynch that would reverse the denials of H-2B visas in recent months. The contractors argue that the USCIS is abusing its discretion and is in violation of law when it went from a near 100% approval of H-2B visa applications to a near 100% denial of the same. In their lawsuit, GCA alleges that the federal government changed their policies and procedures for the H-2B program without due notice and without providing for input on the matter. But in their defense, the federal government says a previous approval a contractor may have obtained does not guarantee future approval, even if they were based on the same facts or need. Sokolower says that the policies GCA cites, quote, merely define the peak load and one-time occurrence standards of temporary need. They do not provide the plaintiffs a cause of action or create any entitlement to approval of an H-2B petition once these standards have been established, end quote. To the contrary, Sokolower points out, as approving H-2B petitions on the same basis would actually show that these workers, quote, have become a part of the employer's regular operations, end quote, which eliminates classification of peak load. In fact, she goes on to note, this appears to be the very basis on which many of the contractors' H-2B petitions were denied. In addition, Sokolower appears to disregard the Guam Department of Labor's authority in screening the H-2B applications, saying the claim that the USCIS is bound by Guam DOL's assessment is meritless. This, Sokolower argues, is because even if Guam DOL approves a temporary labor certification, the U.S. Department of Homeland Security ultimately has the final say.
You can read the motion to dismiss filed by the U.S. Attorney General's office online at pacificnewscenter.com.